staff indicated that. You can argue with me all you want, Ms. Tobe. What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading, you signed it. Your former client had no knowledge of it.
That is not,
was delayed.
Not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond. The amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to and the delay that you caused. It was set in that amount. What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14th, 2026, 9 a.m. Thank you. Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Yes.
Good.
State your name.
Donna Tope. I'm hearing on behalf of myself.
All right, Ms. Tope, I had issued a bench warrant for your arrest for failure to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt and the warrant for your arrest. That is your motion before the court today.
Yes.
Go ahead.
So I would like to put this on the record for my own purposes and also for YouTube. The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and for other cases. And therefore, I would like to have this on the record.
Have what on the record?
What I'm going to tell you now in my defense.
Go ahead.
Okay. It's my motion. The following enumerated facts support my motion to remove and expunge from every record, including the YouTube video, A, your order for contempt, your warrant issued for my arrest, and your order to hold me under arrest on $10,000 cash bail. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Weedling. I opened the email the morning of Tuesday, February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney. Not having had any notice of appearance for this hearing, I was not able to get to the court in time, so I sent Ms. Weedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I receive all of my business mail at Post Office Box 1283 in Ann Arbor, Michigan 48106. I check my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Weedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box, 2 days after the hearing was held. The photos included with my email to the court are of a motion affidavit in order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. The motion at number 2, page 1, states, I am being held by the judge in contempt for filing a pleading without my client's knowledge, nor being the attorney of record. At number 3 on page 1, Judge Simpson requests an order to show cause why I should not be found in civil contempt of court. Can you attach it for me? Thank you. At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2 of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th. The date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the quote, service by mail within 14 days required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, 14-day notice by mail. The facts are that I was not properly served nor properly noticed of the hearing at which Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. Based on what I have provided, the judge's motion and order in the mailing envelope, I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge, so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts, and reissue with proper notice to me the show cause hearing the judge wishes to impose upon me. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice. I will stand on the record that Brandon Davis, no response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Court calls case of People versus Theodore Edwards.
David I. Goldstein.
Theodore Edwards.
We have a plea worked out in this matter, Your Honor. Mr. Cook is going to add a count of
Do I have
the advice of rights.
I have the advice of rights? Do I have a plea form?
Oh, no, sorry.
I'll pass it. Yeah, please. Court calls case of the People versus Michael Elkins.
People. Where's the judge? Or shall the people?
Ron Brown appearing on behalf of Mr. Godwin.
Sir Godwin. Yeah. bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500. Give a 10% privilege. That warrant will issue immediately. Court calls the case of the people versus Tony Gomez.
Morning, Your Honor, reading for the people.
Ron Brown appearing on behalf of Tony Gomez.
Tony Gomez?
Your Honor,
Yes.
we're in the process of having him evaluated for the Veterans Court in Dearborn. I've been in contact with him as of yesterday. I'm requesting an adjournment so that we can complete the process. My colleague did submit, I believe, a MOU in November. Ms. Perini.
I don't know, but we don't know where he is.
Your Honor, he is not in custody, but I've spoken to him all Friday, Monday, Tuesday.
Well, I'm gonna issue a bench warrant. Bond $7,500, 10%. That warrant will issue the 20th. Okay. Court calls the case of people versus Joseph Hamby.
Morning, Your Honor, reading for the people.
Ron Brown appearing on behalf of Mr. Hamby, Your Honor.
State your name, sir.
Joseph Hamby.
What are we doing?
I'm requesting an adjournment, Your Honor. April 15th.
Why?
My information is the vehicle in question is not drivable. I'm trying to obtain verification of either transfer of title or scrap title so that there's no vehicle, proof we have no vehicle in the household.
April 15th, 9 a.m. Fine, continue. Court does call the case people versus Wilmer Hudson.
Morning, Your Honor, reading for the people.
Ron Brown appearing on behalf. State your name, sir. Homer Hudson.
I have a plea form indicating that he's going to plead to attempted resisting and obstructing a 1-year offense upon a successful plea to, well, this form isn't filled out correct. Well, is this charged as an attempt?
Yes, it is. Yes, it is.
So he's pleading as charged to attempted resisting and obstructing. And then there's a prosecutor who will recommend no upfront jail. That's the court's full understanding.
That's correct, Your Honor.
Yes, sure.
That was one.
Raise your right hand. Do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth? You got it. Yes. State your name, please.
Homer Hudson.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yeah.
Still wish to plead guilty?
Yeah.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You've signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
May 5th, 2025, at the location of Ellsworth at Stone School Road, Pittsfield Township, Washington County, State of Michigan. Did you come into contact with officers from Pittsfield Department of Public Safety?
Yes.
What happened?
Well, did they order you to pull over and exit your vehicle? Yes. And did you refuse their lawful commands to pull over and exit your vehicle? Yes.
All right.
And they were in uniform and you knew they were Pittsfield police officers? Yes.
All right. Sir, I do have to advise you, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
9th at 12 noon.
April 29th, 2026, 12 noon.
I'd ask bond continue.
Continues. Court calls the case People versus Austin Ingram.
Your Honor, read for the people.
Defender on behalf of Mr. Austin Ingram.
During a plea.
Austin?
Hi.
State your name. Say your name, please.
Austin Ingram.
Thank you, Judge. I did speak to Mr. Ingram and father yesterday. I believe they're requesting this matter be set for final settlement conference and jury trial, Your Honor.
Jury final settlement conference in this matter, April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Judge.
Bond with its conditions will continue. Thank you.
Thank you, Judge.
Court does call the case People versus Devon Foster.
Raymond Cook for the people.
Judge Torshell Feaster, Assistant Public Defender, appearing on behalf of Mr. Javon Foster. Please state your name for the record.
Devon Foster.
Thank you, Judge. It looks like he was recently arraigned. I believe we'll be asking for an adjournment to speak to Mr. Foster and see what possible resolutions there are.
During the matter, April 1st, 2026, 9 a.m. Bond continues.
Thank you, Judge. You got a comment?
Good. Court recalls the case of the People versus Theodore Edwards.
Morning, Your Honor, Raymond Cook for the people. I Goldstein is bringing on behalf of the defendant.
Theodore Edwards.
Now, Your Honor, we have reached a plea agreement. He's going to plead guilty to an added count of retail fraud third and make restitution. Exchange, the people are dismissing the original charge.
So, he's agreeing, the defendant's agreeing that he'll pay restitution.
Yes, Your Honor.
Your Honor, for what it's worth, I don't believe there will be any restitution owed on this case. My understanding is
Okay, but if there is any, obviously the agreement is he will pay.
Okay. And I just added that to the form, that he agrees to pay restitution if any. And that's the court's full understanding of the agreement. Is that correct?
Correct, Your Honor.
Kevin Swan.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. State your name, please.
Theodore Edwards. Sir, it is this court's understanding that you are going to be pleading guilty to the charge retail fraud third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
That wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yep.
You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Correct.
Are you on probation or parole?
Misdemeanor.
He wasn't at the time of this offense, Your Honor. He is now.
Has anybody promised you anything other than what's
No.
stated here today on the record to get you to plead? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Absolutely.
of your own free will
Yes, sir.
and because you believe that you're indeed guilty of this offense?
Correct.
On the date of July 21st, 2025, at the location of 37 49 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Target store that makes you forget?
I had some items that wasn't purchased.
Okay, so you went into the store,
Yes,
picked up some items and tried to walk out without paying for them?
yes, sir.
All right. And the store was open to the public at the time?
Excuse me?
The store was open to the public at,
Correct.
you didn't have anybody's permission to take that property, did you?
No, sir.
And the property that you took was property that Target had offered for sale?
Absolutely.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court has to advise you that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Correct.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant's referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2006.
29th, Your Honor, that's fine.
Yes, 12 noon.
9, I'm sorry,
Bond will continue.
9 o'clock,
Noon.
noon.
All right, sir, make sure to stop down at my probation department about halfway down the hallway.
Okay.
All right, on the left-hand side.
All right.
May I approach for a moment, Your Honor?
Ma'am. Well, that was fun. Court does call the case of the People versus Albert Wilson.
And your agreement goes to the people.
Your order on behalf of the defendant, John. Appreciate the brief adjournment, court permitted. To discuss this. With Wilson, he has read the advice form that was tendered to him. He's re-signed it. It's like, put your ears up. Yeah, okay, good.
You hear me?
Yes.
All right,
And he has signed it, so I'm sure that he's familiar with it, Your Honor.
all right.
We've also
Are you
signed.
signed and gone through that advice of rights form, sir?
Yes, I did.
Any questions regarding any of those rights?
No.
All right, look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are for trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, he said that.
All right. You understand that you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, he signed it.
Has anybody promised you anything other than what's been stated here today,
File.
which is nothing? Get you to plead to this case.
No.
Anybody threatened you or coerced?
No.
You're doing this voluntarily and of your own free will?
Yes, I am. Your Honor, I might amend that if I might. We have an agreement with the prosecutor that the prosecutor is going to recommend community service. And if the court doesn't give him community service at the time, then he has the right to withdraw. That's the only,
I am not, you guys can agree to, I am not agreeing to.
I understand that, Your Honor.
And to make it clear, the plea form that I believe was handed over says that the people are recommending the community service instead of jail. I understand that the court is not bound by that, but that's what the people will be recommending.
Yes, Your Honor. The other thing we would request is in discussions with the prosecutor, Mr. Wilson has had, as I think the court is aware, has had some difficulty, justifiably or not, with the testing of required by the court. And the prosecution suggested that he wear a scram, and Mr. Wilson is okay with that. If the court
I don't know
will accept that.
with that now. I'm in the middle of a plea. I don't even have a plea.
I just wanted to make that clear to you, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today, which is really, as I said, nothing to get you to plead?
No,
Has anybody threatened you or coerced you in any way?
no.
Doing this voluntarily and of your own free will?
Okay.
And also because you believe that you're guilty of this offense?
Yes.
September 7th, 2024, at the location of 5915 West Michigan Avenue, Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What did you have and how much?
Well, it's vodka, but I don't exactly know.
All right, but you were drinking vodka before you drove?
Yes.
All right. Were you stopped by the police or was there an accident?
Well, I wasn't neither, actually. I was stopped in a parking lot when I walked out of a building.
Okay, so you would admit that you drove into a parking lot?
No, I didn't go into a parking lot. I parked on the side of the road. The Michigan Avenue was torn up at the time and they were laying down asphalt and to get into the liquor store,
Pardon?
get into the liquor store, I would have had to drive over a big bump. Like the asphalt, but it was maybe a foot, and I thought it might hurt my car. So I parked on the side of the road.
Okay, so you drove to the side of the road, you parked on the side of the road,
Yeah.
you went to the store,
Yes.
you came back out.
Yes.
Okay, but you admit that where your vehicle was parked, you drove it to that location.
Yes.
All right. Did the police arrive? Or they were out there when you came out?
An officer walked up to me when I came out of the building.
When you came out of the store?
Yeah, and he put handcuffs on me. So on.
Okay, he didn't put handcuffs on you right away?
He did.
Did he say why he was doing that?
No, he didn't arrest me.
What?
Well, as far as verbally, no, he didn't arrest me. I don't recall that at all. He took the package I had in my hand first, and he put handcuffs on me. And a little later, he asked if I take a breathalyzer, and I said no. And yeah, that's what happened.
Okay. Are you challenging the right of the police to stop you and arrest you in this instance?
Well, no, thank you.
Well, what?
We're not challenged. I do not challenge.
Okay. And so you were ultimately arrested.
Yeah. Yes, Your Honor. You.
Were you taken to the hospital for a blood draw?
Yes.
What were the results of that blood draw?
I don't know. Suppose you have the record.
Would it be 0.124?
I don't know.
Okay, if I told you it was 0.124, would you have any reason to dispute that?
No.
All right. Sir, were you previously convicted on or about February 15th, 2022 in the 14A4 District Court, that being Saline, on the charge of operating while intoxicated?
Yes.
All right. And sir, I just so that our record is clear, when you parked that vehicle on the side of Michigan Avenue,
Yes.
correct?
Yes.
You had drank vodka prior to arriving at the place where you parked that vehicle?
Yes.
All right. Sir, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I understand, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon. As to bond in this case, he wishes to be switched to, he's currently on a sober link, right?
Yes, Your Honor.
And he wishes to be switched to a scram.
Yes, please.
And we'll switch to the defendant. We'll prepare an order switching him to a scram. Do you have the silver link with you?
Yes.
All right, you can go over there. We'll send the order over and do that. Anything else on this?
No, thank you, Your Honor.
Oh, pardon?
That's it for 9
That's it for 9 a.m. All right, then I'm gonna take a break. My first one. Court does the case of People versus Jason Smith.
Brett Silver on behalf of Pittsfield Township.
Portia Feaster, Assistant Public Defender on behalf of Mr. Smith. Mr. Smith, please state your name for the record.
Jason Smith, good morning, Your Honor.
Good morning, sir.
Thank you, Judge. I did meet with Mr. Smith. He does have some other cases in circuit court pending. If we can adjourn this matter to the end of April or early May. We think we can get everything resolved.
What's my last date in April? What's my first date in May?
Basic.
Turn the matter to May 6th, 2026, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you, Your
Thank you,
Honor.
Miss. Thank you. Court does call the case of People versus Aisha Anderson.
Morning, Your Honor. Raymond Cook for the people.
He should be coming.
Oh. Grace Anderson. That's you, ma'am?
Yes, yes.
All right. Ms. Rushing? Okay. Ms. Rush? Oh, there she is.
Sorry, Judge, I was on the record in another court. Good morning, Your Honor. Sydney Rushing, appearing on behalf of Ms. Anderson. I am standing in for her attorney of record, Mr. Brandon Bird. And Ms. Anderson, is that correct? And with your permission?
Yes.
All right, very good. All
Your
right,
Honor, if I
what
may.
are we?
Your Honor, in this matter, all of Ms. Anderson's matters have been submitted to, I believe, the mental health court for consideration. We're asking for this case to tag along with those matters. So we're just asking for adjournment. I believe that you set her next PCC date out to, I believe, the beginning of April.
All right. So I'll adjourn this. I have April 1st.
Yes.
I'll adjourn this matter to April 1st, 2026, 9 a.m.
Thank you so much, Your Honor.
Thank you.
See you tomorrow.
Good
Have a great day.
Two. Court calls the case of the People versus Penny Muldoon.
Your Honor. Raymond.
Good morning, Your Honor. Edward Drugas on behalf of Muldoon, who is approaching.
Hello, what's your name?
Penny Lynn Muldoon.
I have a plea form indicating that she's going to plead to an added count 2 of operating while visibly impaired, 93-day offense. Upon her successful plea to that charge, count 1 is dismissed. The court's full understanding of it.
That's correct, Your Honor.
Yes, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Penny Lynn.
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days of jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
In understanding that, you still wish to plead guilty
Yes, sir.
to that charge? How do you plead?
Guilty.
That you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form, is that correct?
Correct.
Any questions regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir. I understand.
You understand you're giving up your right to appeal outright.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
On the date of September 29, 2025, at the location of 5400 South State Street, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes, sir.
And that was cocaine?
Someone gave me and I knew it was from the streets, a Percocet. So I didn't really know what was in it.
Okay. When you say somebody gave you something, you don't know what you took.
I believed it to be a Percocet, but I knew it wasn't.
Okay, but
It was not prescribed to
it
me.
was not prescribed to you,
Correct.
correct? Okay. Were you stopped by the police or were?
I was driving someone to work in the morning. I remember pulling away, not feeling very well, pulling off into the lawn, and that's the last thing I remember. I fell asleep.
So you were on South State Street and at some point you drove off the road.
I was in a parking lot of a factory.
And at some point,
Yeah.
operating the vehicle and you drove off the asphalt and onto grass.
Yes, sir.
To a grassy area.
Yes, sir.
All right. Did the police arrive?
Yes, sir.
Were you ultimately arrested?
They sent me to be tested.
Okay. So
They sent they drove me to the hospital to be tested.
Cuffs?
Yes.
Wearing cuffs.
Yes, sir.
You were probably arrested.
Yes.
Okay. So they took you to the hospital, right?
Mhm.
And then there was a blood test.
Mhm.
Yes?
Yes, sir.
All right. And did the results of that blood test indicate the presence of cocaine?
Yes, sir.
All right. Do you have any reason to those blood test results?
No, sir.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was impaired due to your ingestion of a controlled substance?
Yes, sir.
Ma'am, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
None from the people?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendants referred to bonds works for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
April 29th at 12 noon.
April 29, 2026, 12 noon. Bond will continue.
Thank you.
All right, thank you. And stop down at my probation department on your left on your way out, please.
All right.
Thank you. Court does call the case of People versus Thomas Kumasaka.
Henriette Silver on behalf.
Kumasaka.
Good morning, Your Honor.
Your name, sir?
Thomas Kumasaka. Your Honor, I'm asking for an adjournment in this case. He has a next Thursday, and my understanding there's going to be a resolution on that day, and it's going to resolve our case. So if we could adjourn it till after.
April 1st.
Thank you.
2020, 9 a.m. bond continued. Thank you. Court calls the case People versus Austin North.
Henriette Silver on behalf of.
There's been no rain on this.
Okay.
Good morning, Your Honor. Robert Ellman with and on behalf of Mr. Norton. In terms of the arraignment, we would stand mute and waive formal reading, but Mr. Norton, can you please state your name for the record?
Austin Norton.
We waive formal reading, standing mute, court will enter a not guilty plea. What are we doing?
Your Honor, Mr. Siller and I are working on a resolution of this case. We need a little more time to get some of that paperwork done. I'd be asking for a little bit longer of an adjournment if you would to
April 15th work?
Yes, sir.
Adjourn the matter to April 15th, 2026, 9 a.m. As to the defendant's bond, his bond will be set in the amount of $5,000 personal recognizance bond term on all of the standard conditions, including no assault to behavior and or possession of any weapons or ammunition. You understand that, sir?
Yes, sir.
And I'm also going to order at this time no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that? Okay. Thank you. Court calls case People versus Christian Bird.
Conrad Siller on behalf of Township.
Very good. Marshall Feaster, Assistant Public Defender on behalf of Christian Bird, who is approaching the podium. When you arise, please state your name for the record.
Christian Bird.
Thank you.
Thank you, Judge. I did meet with Ms. Bird yesterday, and I did speak to Mr. Chablowski, who has her case up for tomorrow in front of you for PCC. We're working on a global resolution. Brief resolution, please, Judge. Brief adjournment.
Adjourn the matter April 1st, 2026, 9 a.m. Bond continued.
Thank you.
Thank you.
All right, later. Thank you.
Court calls the case of the People versus Joshua Wall.
But on behalf of Mr. Wara, let me give you an update, Judge, for what went down since you modified the bond. Josh was released into the custody of U of M ER. He is now presently at Havenwick Hospital. I've been advised that his stay is 7 to 14 days, but I'm working on obtaining the admittance or discharge paperwork from U of M, and I will provide it to your court staff. I'm asking for 2 to 3 weeks adjournment.
Without objection, April 1st, 2026, 9 a.m.
Thank you, Judge.
Thank you.
Bye.
Court calls the case People versus Norman John. Norman Johnson versus Norman John. Norman Johnson.
Sherilyn Foster Tucker on behalf of Norman Johnson.
Norman Johnson. Thank you.
Your Honor, we're requesting an adjournment. He has a case up at Circuit Court and we're hoping to work out a global resolution.
What's that?
I think his next pretrial is Monday.
Monday of this
20. Yeah.
April 1st, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls the cases of the People versus Ryan Brown.
Your Honor, any book of the people filing.
Ron Brown appearing on behalf of Ryan Brown.
Conrad Siller on behalf. Yes, please do. Township.
Your Honor, case 610 is in arraignment.
Which one?
610.
Here. Ryan Brown. No response. Bench warrants will issue for the defendant's failure to appear in each of these matters. Bond will be set in the amount of $5,000, 10% on each case. Those warrants will issue immediately. Court calls the case. Yeah. Great. And can you contact Paul, make sure he's gone? Court calls case People versus Justin Randolph.
Ring Cook, file ending in 0556.
It's still around behalf of Eastfield Township.
Court Judge Torshall Feast, the first assistant public defender on behalf of Mr. Justin Randolph, who I do not believe is going to be present, Your Honor. There was a progress report that was sent to our office that indicated that Mr. Randolph County Jail via VineLink.
What?
They believe that he was in the Livingston County Jail. It's on a VineLink search.
Okay, and that he remains there.
Yes, Judge.
Okay.
Requesting.
Want me to adjourn them out?
Yes, please.
We can try to do that. I'll adjourn these matters April 1st. 2026, 9 a.m.
Thank you, Judge.
Bond will continue in these matters. Court does call the case People versus Reese Palmer.
Ring Cook, Keisha.
Your name, sir?
My name is Reese Palmer, sir.
The PD.
It's a public defender case. Well, they don't have all this to. But
Ready, Judge Torshall Feast, the first assistant public defender on behalf of Mr. Palmer. Nice to meet you, sir. Please state your name for the record.
Reese Palmer.
he hasn't been arraigned. He is not.
Equal.
All right.
On to do.
All right. What are you gonna do today?
When I adjourn your court and arraign you. He's looking at you. We're ready, Judge. Did you say you had to arraign him?
No, he's been arraigned.
Okay. Thank you, Judge.
Well, sir, this is what I'm trying to do. I got stage 4 cancer, sir.
Pardon?
I got stage 4 cancer. When I caught this case, sir, when I got this case a year and a half ago, almost 2 years ago, whenever it was, I was homeless. Now I'm not homeless. I'm on disability. And I can't take chemo while I'm in the county jail. So please, I'm trying to get a personal recognizance bond so I can get out and take my stage 4 chemo. This is the last chance I got. If this don't work, then definitely I got to go see God.
All right.
I guess that's his bond request, Your Honor, and he's requesting it.
Well, if I can get information, I'm not going to have a problem with the release.
Okay.
He
needs some proof.
Does he have other cases pending?
Your Honor, I see he has another case set for PCC tomorrow with $1,000 custody bond. I'm trying to open that jail right now to see if there's any out of county holds. I would also, looking in our system, I do see there's 2 new cases with dates of offense, February 21st and March 10th. I have not reviewed those, but it looks like they have been requested for charges as well.
What I'll do is I'll adjourn this matter to April 1st, 2026, 9 a.m. And if I can get medical, then
And that is where this courtroom moment becomes more than just a discussion about money. At first, the case seemed straightforward. There was an accident, insurance had covered part of the damage, and the remaining amount was being presented to the court as restitution. But Judge Simpson stopped the process with one important concern. Was every dollar being claimed actually caused by this accident? That question changed the entire direction of the hearing. Because when restitution is involved, the court can't simply rely on a number written on a document. The damage has to make sense, the evidence has to support the claim, and the court has to be confident that the amount being requested is actually connected to the incident. And that's exactly why Judge Simpson considered a restitution hearing rather than rushing through the agreement. What I find most interesting here is that the judge wasn't necessarily refusing to consider the payment. He was making sure the fact came first. A defendant can agree to pay. An attorney can negotiate an amount. Insurance can cover part of the loss. But before the court makes that number part of the final outcome, there still has to be a reasonable basis for it. And that raises the question for you. Do you think Judge Simpson was right to stop and question the $4,200 claim? Or should the court have simply accepted the agreement and moved forward? Let me know what you think in the comments. And if you enjoy courtroom moments where one question from the judge can completely change the direction of a case, make sure you subscribe to FactSpark. Because sometimes the most important moment in court isn't the final ruling. It's the moment the judge says, "Hold on, stop." Thanks for watching, and I'll see you in the next courtroom case.